In 1987, when I was about 20 years old, authorities arrested me and put me in prison. And at that time, we had a completely different sentencing scheme in place. A few years later, the Sentence Reform Act came and became implemented in sentencing courts across the country. And later, there was this new program. It was the 1994 Comprehensive Crime Control Bill that brought forward a program known as the Residential Drug Abuse Program. That was the most significant piece of prison reform movement since the start of the Sentencing Reform Act, because it was the only objective program that somebody could take advantage of to advance their release date in an administrative way. But a lot of people didn't understand it. And that program, I was incarcerated at the time. I remember when it started, and I remember how many years it took to evolve. Well, recently, we have had a new piece of prison reform legislation that is even more significant than the 1994 Comprehensive Crime Control Bill, and that is the First Step Act. Today, I have the privilege of sitting with my friend, an Orange County defense attorney who specializes in mitigation expertise and sentencing and helping white-collar people who are charged with white-collar crimes in federal court. Today, we're going to be talking about the First Step Act. Diane, do you have what level of knowledge do you have about this really important piece of legislation?
So, Michael, my background and understanding of the First Step, it's very preliminary. I know that you and your friend Sean Hopwood were very instrumental in passing this bill. So I would love for you to tell me from your perspective, based on your experience, your understanding of the First Step Act and how it would apply to my clients.
I think it's important for you and your clients to really understand it, because sadly, many people come into the system and the only thing they're thinking about is sentencing. And that's understandable. These are not criminogenic people, if they're most of the time, that are charged with white-collar crimes. And they don't understand how every single decision can have an influence on their future. And that's something that, as you said, Sean and I really understood, because we served a long time in federal prison. And we understood that if you want to influence the outcome, you got to start sowing seeds very early. So the First Step Act, the main thing that your clients really want to be thinking about is that mitigation is important at the pre-sentence investigation era. It's important at the sentencing era. But it's really important once somebody goes into the system as well, because now an individual has the right to have a judge revisit their sentence. And that didn't exist before. So I'll let you know that there is steps that you could be doing in working with your clients to help them understand that. And it's really about doing the same thing that you do so expertly in persuading stakeholders at very early stages in the journey to either reduce the charge that they're contemplating against the defendant, maybe resolve the matter before there is a grand jury indictment, maybe work toward a cooperation agreement or a mitigation strategy that can result in maybe a home confinement or a lower sentence. Now it's a lot more important than that, because after the sentencing hearing, the person goes into the Bureau of Prisons and the person can argue in administrative ways to get a reduction in sentence. And thousands of people have been released since the signing of the First Step Act. Tens of thousands have not been released. You know, it's a matter of how hard is the individual working to build a strategy to differentiate him from everybody else. So I think it's important for you to help your clients understand that there's kind of a process that somebody has to go through. The first step is a person has to build a record that suggests the individual has a compelling reason for early release and an extraordinary story. So that doesn't mean that they found Jesus and they missed their wife and kids. Although those may be important factors, that's probably not going to move the needle in a compassionate release case. But if somebody has figured out a way to make amends, to reconcile with victims, to reconcile with society, to build a strong record that shows this person has really learned from the experience and is unlikely to be a criminal defendant again, well, that person has a story to tell. And then they need to hire somebody like you to present the case. Because the first step is they put it an administrative remedy in the prison system, and the warden has 30 days to respond or to deny. But after the warden either doesn't respond or denies the petition for early release, then the individual, through counsel or pro se, can file a motion asking for reconsideration and compassionate release. And that compassionate release, Diane, can be a number of things. The judge has wide discretion to allow the person to serve the sentence at home or to just completely conclude the sentence. And the person can be free from the other sentence that could have kept them in prison for many, many years. In fact, we profile somebody on our site that had a 200+ year sentence. And after the First Step Act passed, he was successful in getting home.
That's amazing, Michael. So I have a question, because a lot of people have been getting out because of COVID, and a lot of people haven't been getting out. So do you think that the distinction between those two categories are people who have also been doing extraordinary work while they're in prison and the mitigation that they had presented at sentencing, in addition to maybe their comorbidity factors?
Yes. I mean, we had a case of a guy who the prosecutor was asking for 7 years or 84 months. I guess that's 7 years, yeah. And the individual put together a pretty extraordinary mitigation strategy. He got at sentencing 3 years against the objection of the government. While he was in prison for less than 9 months, he put his compassion, and the judge commented on this mitigation strategy. When he got to prison, he was there for probably 4 or 5 months, and he put together a compassionate release motion, and the judge allowed him to go home, not only because of COVID, but because the judge again cited his extraordinary responsibility and compelling reasons. And it doesn't happen in every case. Every person's got to sell himself, but the sooner somebody starts working to sell himself, the stronger the record that he builds, the better off he's going to be. And really, they can't do better than hiring somebody like you, Diane, that's willing to listen and document the record and begin populating this story that's going to be built upon. I can give you an analogy that I use when I'm helping people think this through. It's like if you're in real estate and you want to buy a piece of land, you might not know what to do with that land. And so you might want to hire a counselor, otherwise known as maybe a land, to do a study on the land. What's going to be the highest and best use of this piece of dirt? Should I build a hotel on it, a house on it, a warehouse on it, a supermarket on it? Because the choices that I make, every choice that I make is going to have an influence on the return of investment that I receive. But there's nothing more important than your liberty. And you need somebody who's been there before, who understands it. You need an attorney that can help you navigate these really treacherous waters. Because the one thing every single person in prison is going to have in common is every one of them is going to be pounding the door trying to get out. That's a fact. You've got to be thinking, with help from your attorney, what can I do to differentiate myself? And if your attorney's not helping you do that, then your attorney may be a great analytical thinker, assessing what the government can prove, what discovery gets through, what they can prove this beyond a reasonable doubt, all Booker and all these things. But the reality is this is bigger than that. And you've got to be thinking about your entire life. And to the extent that you can work closely, hand in hand with your attorney in crafting a mitigation strategy that you can use for the years ahead, I think you're going to be better off. And that's really what somebody's got to be thinking about very early in the process.
Yes, and I've had the greatest success, working hand in hand with you, using my mitigation strategies and yours, and having my clients speak with you about the road ahead and having you help them write their narrative that I can present to the court. It's an amazing symbiotic relationship. I think that you have such a gift of being able to get people to share their story with you and to articulate it. And I read these letters, and I'm quite frankly always amazed.
It's not only me. I mean, we've got a great team, I want to say, and the people that we work together, it's really the depth and breadth of experience in helping somebody realize how do I recalibrate? How do I help my attorney help me? Because the reality is every individual has got to be willing to come forward and really present a case that will could speak to an audience of, first of all, the judge, second of all, the stakeholders in the prison system, third of all, the probation officers that are going to supervise release, fourth, what about the rest of your career? I mean, it's easy to just think about, I just have to get through sentencing. But as somebody who's really gone through the entire journey, I would advise you to be thinking fast forward 5 years from now, 10 years from now, 20 years from now, and what seeds can you sow today to make sure that this problem is not going to be what's going to define your life, but rather how you responded to the problem.
Exactly. And I do have clients who say, I say, where's your letter? Where's your narrative? Where's your autobiography? Have you hired Michael yet? And they say, well, I just appeared in court for the first time. I don't care. You need to get started on this right away. Because if this person, for instance, the person I'm thinking of, is so concerned about not leaving his family, his wife and his children without a place to live if he has to serve time, that he just is focused on sentencing. But he should be focused on what is going to happen when he gets out. Where is he going to work? He's going to lose a professional license, so he's going to have to completely recreate himself. And that's why it's so important to start really from day one on this process.
The sooner somebody gets started, the better off they're going to be, Diane. And one of the things, we know that our fees are not cheap and not everybody can help us, but we're going to give you some resources that we hope your clients can use because this can be a self-directed path. Everybody can be working with you hand in hand to reveal their story. We give away more content than we sell, and we would encourage you to distribute that to your team and the people so that they can help you help them. The reality is every person should be willing to do whatever it takes to stay home with the people they love and the people who love them. They just need a good guide, and I don't recommend anybody more than Diane Bass, a preeminent defense attorney in Orange County, California.
Thank you so much, Michael.